The environmental activist group does everything it can to stop whales being killed. Another battle that could achieve the same aim is about to play out in court. At the International Court of Justice, Australia will say Japan is breaking an internationally agreed ban, a moratorium on commercial whaling. Japan's defence, that its whaling is for scientific research and therefore allowed, is, Australia will say...
Ever wondered if a country could sue another country? Well, the answer is yes. This video would take you through the system of international law, different types of international law, and then look into separate countries to see how things work for them. It all started in 1945 when the United Nations made a treaty establishing international law. They made a treaty that all the countries signed in acceptance of those rules. International law has three main types: public international law, private international law, and supranational. Public international law concerns the treaty relationships between the nations and persons. An example of this is when a country violates a treaty set and another country sues them. Private international law is a conflict of laws. This deals with conflicts between the private persons rather than states or countries. Supranational law is a form of international law that is based on the limitations of the rights on nations between one another. The United Nations Security Council and International Court of Justice are the only globally accepted supranational areas. Now that we have an overview of international law, we'll go over where it's administrated. There are two main courts, just like our appellate and criminal system back home. The International Court of Justice, or World Court, is the primary judicial branch, and it mainly deals with disputes among states. It has 15 justices and is located in The Hague, Netherlands. The other main court is the International Criminal Court. The ICC is intended to complement existing national judicial systems, and it may therefore only exercise jurisdiction when certain conditions are met, such as when national courts are unwilling or unable to prosecute criminals, or when the United Nations Security Council or individual states refer investigations to the court. The sentences they have are international crimes of genocide, crimes against humanity, and war crimes. Here's some more info on it.
Of really important clarifications. One, the ICC doesn't try states, but rather individuals. And two, the ICC really only has jurisdiction over cases that fall under the who, what, and when of its operating treaty. That treaty is the Rome Statute, which in general limits the court's jurisdiction to alleged crimes committed after 2002 when it was ratified. Crimes it investigates and prosecutes must fall under 4 core categories, and the crimes must either have been committed by the national of a state party or happened within a state party's territory. That includes 34 African states, 18 Asia-Pacific ones, 18 Eastern European ones, 27 Latin American and Caribbean states, and 25 from Western Europe and elsewhere. Not party to the statute? The US and Israel, both of whom at one point signed but never ratified it. Participation of either in an ICC investigation would therefore need to be voluntary.
The whole international law system depends on countries' consent in following it. In this map, the ones that are red have ratified, yellow signed but did not ratify, and gray has done neither. Now that we've looked abroad, let's see inside several different countries' judiciary systems. First up is Australia. Australia has 3 courts which all cases go through. Their names are the High Court of Australia, which is the supreme rule of the land and has constitutional review. The Federal Court of Australia, which takes in cases about corporations, trade practices, and bankruptcy, immigration, and other areas of federal law. The last one is the Family Court of Australia, and they just deal with family law matters while being the lowest of the courts. Next is the Honduran judicial system. The courts consist of a Supreme Court of Justice, courts of appeal, courts of first instance, and justices of the peace. The Supreme Court has 9 justices, with 3 in each branch of civil, criminal, and labor. Next is the Court of Appeals. They have 3 judges as well for all 4 branches of civil, criminal, commercial, and habeas corpus cases. The first instance courts serve as trial courts for serious civil and criminal cases. The last court is the Justices of Peace. These are spread throughout the country. Populations that are more than 4,000 get 2 judges, and areas less get 1. The focuses are on investigation and deals with more minor cases. Now we have the People's Republic of China. They have 3 courts: People's Courts, People's Proctorate, and Public Safety. Under the People's Court, they have the same hierarchy as our judicial system. China's People's Proctorates are state organs for legal supervision. Basically, they deal with state-level cases, investigations, provide supervision, and to have a grand jury. This branch also has a supreme level and a local level. The public security leads and directs the people's police. They also keep social and public order within China. Last is the Indian judicial system. The system there became another form of British law from when they were a colony of the UK. They have 4 courts: the Supreme Court of India, High Courts, District Courts, and Village Courts. Their Supreme Court has 1 chief and 29 other justices presiding. In India, there are 24 High Courts, which are at the state level. District Courts are made by the High Courts and has to listen to what the High Courts say. Village courts came about as floating courts around India to settle the smallest of cases with a max sentencing of 2 years. Did you notice the similarities to America's judicial system? Well, think about it, because law is everywhere.